conveyance. Good, I'm being recorded. Great. Okay, you have my permission to record. So in any event, when the deed is prepared, uh, we call this a conveyance. To convey, convey, convey is a word that means to transfer to somebody, to convey or to give. For example, I am conveying a message to Natalia that she is to go to her school tomorrow morning at 9 o'clock to pick up some papers for her child. Okay, so when we transfer property, we call that a conveyance, and we do that through a deed. Okay, in property law, contracts can often be oral. We can agree to things contractually orally many times. But property is different. We have to have a written contract and then we have to have a deed for it to be enforceable. Okay. So I showed you the deed. Then what happens is the deed, and you can see here the name of the person transferring the property is also called the grantor, and whose would be the buyer or the grantee. Okay. As the grantor, I have to sign that deed. And then I give the deed, I give the deed um, to the land registry office. And I looked this up, I think in Uzbekistan, that is called the Real Property Registration Office and Cadastre, Cadastre. I think that's correct. But in any event, every country, in America, every state, every county, it's very important they have a land registry, okay? And the land registry is simply an office, and they keep all of the deeds in the land registry's office, okay? And that deed becomes notice to the whole world. It puts the whole world on notice that I have transferred or I have conveyed my interest in real property to Dilsuz, and she is now the true owner, okay? Okay,
Professor,
so deeds are very important. Yeah.
I have a question.
Yes.
Uh, do we use deed only with real estate or with any kind of property? And it confirms your right to the possession.
Yeah, that's right. No, it's for real property only, and that's true. And we can talk further about what we call the chain of title. The chain like a chain on your child's bicycle, a chain, or a chain you wear around your neck, like I have around my neck. The chain of title. And this is very important in property law. If you go to the land registry office in wherever it is in Tashkent, okay, and lawyers have to know this if they're involved in property law, you can go and you could give the clerk who's working there the address of the property and say, I want to look at this particular file, or you can maybe go online and do it. And you would be able to see you would see the current owner of that property. In this case, it would be Dilsoos. Before that, it would be Professor Heller. And before that, it would be anybody else who would own the property. Okay. So anyhow, very important because that way it's very clear who owns the property, who has an interest in the property, and then the land registry, is also involved in taxation. So whoever owns the property is going to be, unfortunately, they're going to have to pay a tax. The other thing, though, I want to say about deed, and here's again one of the problems with English, and I told you about this in the beginning, is that many English words have both a common meaning, an ordinary meaning, and a legal meaning. So in the law, I've explained what deed means. The ordinary, and many people who are not lawyers would not know this. They wouldn't, if you go to a party and you have 10 people, one lawyer and the other 9 people not lawyers, and you said, what does deed mean? The lawyer would say, oh, that's how you convey property. The other nine people who are not lawyers, if you say, what does deed means? They would say, oh, a deed is an act. Okay. So the sentence would be, I'm going to skip this. Oh, the sentence would be, I did a good deed for my neighbor today, my elderly neighbor. I went shopping for her. I did a deed. A deed is an act. Okay. This next slide is, I'm going to skip over this probably, but it's just to indicate that there are various types of deeds. They're not all the same. But anyhow, that's probably more than we need for today. Okay, so here's the picture to help us learn. What does this say? Crush those seditionists, but who are they? Ah, abet. Aid and abet. Aid and abet. You may have heard of the word aid, like to give first aid, okay? Give somebody medical help, come to the aid of somebody. And abet means to help. They really mean about the same thing, aid and abet. Here's one of the problems with lawyers and our profession is there's something called legalese, which maybe you've talked about or maybe you haven't, but legalese is the horrible, terrible writing that lawyers have traditionally engaged in, and professors are the worst. Okay, professors are the worst at this when they write. And this is called what is known as a doublet. Doublet means two, like double. Okay. A doublet is two words, aid and abet. Well, that's three actually. But aid, abet mean the same thing. You don't have to say them both, but oftentimes lawyers say the same word twice. I don't know why. It makes us feel important if we can say many words and confuse our clients. Like null and void. We don't need to say null and void. Void is enough. Or null is enough. Void means to wipe something out. It never existed. It's void. It's done. Same thing with aid and abet. We really don't need two words to say the same thing, but that's legalese. Okay. This is a criminal law term. Okay. The deed was a property law term. This is a criminal law term. And it means to assist somebody when they are committing a crime or to encourage them. So let's say, for example,
Sorry.
Natalia,
Is it
yes,
is it synonym to criminal?
this is criminal, yes.
Hmm, got it.
This
Thank
is this is to aid and abet is actually a criminal offense, and I'm going to give you an example. We'll pick on Natalia. Natalia, your husband, your husband is planning to rob the bank. I'm only kidding. This is hypothetical. But your husband is thinking about robbing a bank, okay? And he has all these plans on how he's going to rob the bank, okay? He's going to do it at a certain time, and he's going to wear a mask, and he has guns, and he has this all planned out. But he needs your help because he cannot do this all by himself, okay? So you are going to drive the car. You're going to be the getaway person in the car, okay?
I'm
So
a bit tired.
yeah, you're the pilot, you're the driver. And so you're going to take him to the bank, you're going to drop him off, you're going to wait outside the bank, and when he comes out with all the money, you're going to put him in the car and drive him away. Or maybe you're the person that is going to hide all the money after he's stolen it. And he comes to you and says, Natalia, I have all this money. Would you mind, would you mind hiding it? You say, yes, I'd be happy to hide it. So you are the person, Natalia, who has aided and abetted your husband in the separate crime of robbing the bank. Okay, you are an aider and abetter, and you are just as guilty as your husband for robbing that bank. Okay, so this happens all the time in the criminal law, as you can imagine, because there's very often more than one person involved, and sometimes many people involved in a criminal enterprise. And so that person is said to have aided and abetted the commission of a crime when acting with knowledge of the unlawful purpose of the main person committing the crime by encouraging and facilitating, which are big words for simply aiding the commission of that offense. Okay, so aid and abet. Okay, aid and abet. So aid again has one meaning in ordinary English. Aid means to give first aid to somebody maybe who is injured. Aiding and abetting has a separate legal meaning. Okay, aiding and abetting. Okay, what is this? This is a little drawing or a little sketch, and you can see that there are four streets. These are public streets where people would drive their cars. There is then a sidewalk around the streets, and then we have various lots. You can see it says a regular lot, three-street lot, front, back, and rear. Okay. So again, this is a property law. We're talking about property law here. Okay, property law. And the words are abut or abutting. And I have to, okay, I have to minimize. I can't see your pictures anymore because I have to be able to look at my entire slide so I can read it. Abut or abutting. This is a term used when two pieces of land, but we call them a parcel. In legal terminology, we call individual pieces of real property, we call them a parcel. Okay, a parcel. So when two parcels of real property touch each other, okay, either directly or indirectly, and they border each other, we say that those two properties are abutting. Okay, so to go back to the prior slide, if you can look at the to the far right, of the slide, where it says three-street lot, okay, that is one parcel. We call that a parcel of land. And the one next to it that says two-street through lot is a separate parcel of property. And this dotted line where it says side and rear, that is the common property line for each of those two parcels of property, okay? And we say that the three-street lot abuts with or is abutting to the two-street through lot. They abut, okay? Abut. Abut just means they are touching each other, they are connected to each other. The two lots have one property line in common. Okay, for the three-street lot, this would be the rear of the property. And for the two-street through lot, it's the side. And that dotted line means it is that is the area where the two properties touch each other, but in the law, we say that they are abutting. Okay.
Can we use this word when we mean two rooms in one apartment and they touch each other? Can we say that they abut?
Yeah, we probably we could say that. Yeah, that we could say that. But ordinarily, these words are a little bit more specific. We usually use these words, Natalia, abut or abutting, in connection specifically with two parcels or pieces of real property, land. Okay, So, no, you have the right idea. And the question was, if you didn't hear it, if we have an apartment or a flat and we have two rooms that connect each other, let's say the living room area and a bedroom area, do they abut? Well, yes, they do abut, really, because they're right next to each other and they might even share a common wall. So, yes, they abut, but we usually don't talk that way in English. We usually say that the one room is next to the other one. We usually use or save the word abut or abutting to talk about real property. Notice, however, that I introduced another word here that is not on the slide, but I called the one piece of property a parcel, a parcel, Parcel. And that's a hard word. And again, another problem with English is you notice that I spelled that Parcel, and yes, yet the C sounds like an S, doesn't it? It would make more sense for the word to be spelled Parsel, but it's not. So in legal English, a piece of land, okay, is called a parcel of land, a parcel of property or a parcel, okay? On the other hand, if you order something online from Amazon, and they deliver it to your house, or if you have to go to your post office and pick it up, we also call that package a parcel. So again, that's yeah, and you're probably familiar with that kind of parcel, maybe. It's a parcel in ordinary English is a package or a box of something that you would order. Okay, you can call that a parcel or a parcel delivery. But in the law, we use the term parcel for a piece of land. Okay. A couple of these I'm going to just skip over because we don't have a huge amount of time. Okay, but on slide 13, we have two words, two very small words, as is. As is. Has anybody heard of the term as? If anybody has heard of this, can you just jump in and tell me? Have you heard of as is, and do you know what this means?
I have
Uh,
never met, being honest.
good, good. I like when I hear that because I'm teaching something new that you haven't heard of. This is very important terminology in consumer law. Okay, consumer law. Consumer law deals with transactions between a seller and a buyer, usually of personal property. And in particular, this comes up with used cars, or what we might call a previously owned car. Okay, a previously owned car or a used car. So let me give you an example. If you were to go to your local car dealership where they sell cars, maybe they sell a lot of them sell new cars, brand new cars, okay, and they sell previously owned cars or what we call a used car, right? And if you buy the new car, it is going to come with a formal warranty, Warranty, a warranty, a written warranty. And usually the and warranty means guarantee or a promise. Okay, a warranty means a guarantee or a promise. And this will be in writing. What's the most common uh, brand of car in Tashkent?
Currently. Okay,
What kind of
Natasha, do
car?
you want to answer?
Yeah,
Chevrolet.
what? Huh?
Chevrolet.
Okay, okay. So if you go buy that new car, the manufacturer is going to give you a warranty, right? And the warranty may say something like, this car is warranted to perform without any defect for a period of 3 years or 75,000 kilometers, right? And if there is a problem, then we say that it is in breach of the warranty, and you can take the car to the dealership and they are going to have to repair the defect, whatever the defect is, at their own expense, and you're not going to have to pay. Okay? That's if you buy a new car, and that is what a warranty is. Similarly, if you were to go to your local store and buy, let's say, a new refrigerator, okay, the refrigerator manufacturer is going to have a warranty as well in writing that will also say that the warranty on your new refrigerator is good for a period of 3 years. And then they often try to sell you an insurance policy to extend that for a year or two. But in any event, if your refrigerator breaks within that 3 year period, the manufacturer of the refrigerator is in breach of the warranty, and they are going to have to, a repair person is going to have to come out and repair the broken problem and fix it, or they're going to have to give you a brand new appliance. Okay, so that's called a warranty. And when you buy a new car or a new appliance, they often come with a warranty. As is deals with things which are used, which have been previously owned. So now to go back, same audio, you go to the lot and you say, look, I can't afford to buy a brand vehicle, but I would like to buy a used vehicle. Okay, maybe 3, 4, 5, 6, 10 years old. Okay, because we're talking about English now. Can you hear?
Yes. Sorry, but
There will
your screen
be a
is not.
sign in the window around the appliance that says, yep, what?
No, normal. You can
What's the
continue.
matter?
No, it is okay.
Hello?
There is no matter. It is audible and visible. You can continue.
Yeah.
Ah, maybe it could be an internet problem or something. I don't know.
No,
All right.
everything is okay now.
So in
Yeah.
any event, you will see in the window of the okay, you will see a sign in the window of the car that will say as is. Okay, the car is being sold as is, which means that it is not the seller of that car. In this case, it would be the auto dealership is not giving you any warranty whatsoever that the car is going to work the way it should. You are taking that vehicle, okay, without the right to complain or to come back and tell the seller that the seller should fix it and make it work properly, because you are buying, again, whether it's a house, an animal, an automobile, an appliance. If you buy that as is, it means that um, you are buying it even if it might be defective, okay? The only thing that the seller is agreeing to do is to sell it for whatever price is agreed upon, and you agree that you're going to buy it. An exception is, you can see in the second bullet point here, the buyer must have had the right to a reasonable inspection so that he or she has a chance to see if there is any obvious defect or deficiency. Okay. So what you would want to do if you are buying a previously owned car, or even let's say an appliance, and you are buying it as is, what you would want to do is probably take that vehicle to a mechanic of your choice, okay, that you rely on and you think is a good mechanic, and you would want that mechanic to do a thorough inspection of the vehicle to make sure that the vehicle is in good operating condition. And if the mechanic says, no, that car is not in good condition, it's going to be a problem, well, then you don't buy it. Okay. Because an as-is sale means that you, the buyer, are basically assuming the risk that if there is ultimately a problem with what you are purchasing, you are not going to be able to go back to the seller and get your money back or have the seller repair the problem. Okay, as is means you take it the way it is, you take it the way you find it. It's as it is, as is. Okay, you take it as it is or as is. Okay, again, that's consumer law. I want to talk a minute here about at will, and you probably haven't heard of this. It comes up, this is an employment law term, an employment law term. Again, I'm not sure how things work in Uzbekistan, but this is how things work in America. Okay, it's an employment law concept, employment between a person, a business that is hiring somebody, and the employee. The short phrase at will is found in many employment contracts and suggests that the employee is working solely at the will of or at the discretion of the employer. Employers, an employer versus employee. See, we changed the last three letters of that word from employee, the person who is doing the work, and the employer, which is basically the boss or the person who owns the business and is doing the hiring. If an employer hires an employee at will, it means basically that the employer can terminate or fire. That means the same thing. Notice the word fire too has two meanings. Fire as in burning something. Okay, a fire, the house is burning. That is a fire. And fire in the employment context means that you are being terminated from your position as an employee. And in America, at least, and I know in the UK and some other places in the West, if you are being hired as an at-will employee, it means that as the employee, you have virtually no rights, okay? And you can be terminated or fired by the employer for any reason or no reason at all, okay? So if there is a provision in a contract that says you are at will, it really puts the burden on the employee that is being fired or let go to show that he or she, in fact, had reasons to believe that the employment was permanent. And I don't want to go into this in too much detail because we don't have time. But basically, at least in America, if when you are getting a job, and now I guess they call it onboarding. Okay, so you're offered a position. You might meet with the people in the human resources department. And if the human resources department or your boss or somebody at this new job gives you like a worker's manual, and it's a manual about how you're to behave and your use of the equipment and things of that, when you get breaks and your lunch period and so on and so forth. The more information you are given, written information you, the employer, are given, the more likely it becomes that you are not an at-will hire, that you are, in fact, a permanent worker. Okay. In any event, I just want you, these are a lot of details, but basically, I want you to understand that if you see the phrase at will, and this is will is another problem we have with English because this is an idiom. This is what is known as an idiom. You have heard of other idioms like over the moon. I am excited over the moon. Okay, I'm so excited I don't know what to do. Okay, over the moon. Or busy as a beaver. Okay, those words don't make any sense taken together. They make sense individually, but not together. At will is a similar idiom. You would look at this phrase and say, I have no idea what it means, at will. Okay. So it has a very specific meaning in employment law, and it means that if you are being hired as an at-will worker, as an at-will employee, you have basically no rights. Okay. And you can be terminated at the will of the employer for no reason, even if you did a great job and you did everything you were told. Okay. So it can be to the benefit of the boss. It can be to the benefit of the company to have employees which are at will because, if they want to get rid of you, they can do it just by you walk into work one day and they say you're fired. Why? Why am I being fired? Well, because we have the right to, you are an at-will employee. Obviously, if you're the employee, you're the worker, you don't want to be an at-will employee, right? Okay. Bail bonds. Bail bonds. Free at last, bail bonds, and here's a telephone number. Bail, another four-letter word. This is a criminal law, or really, I would say a criminal procedure term. Okay. And this takes on a constitutional dimension, and it's probably true in Uzbekistan. It is true in most places in the world that have the rule of law and have constitutions. Under the Eighth Amendment to the United States Constitution, there is a right to reasonable bail. What does this mean? So here's what happens in a nutshell. I'll go back to the hypothetical bank robbery situation that Natalia and her husband were planning. Well, guess what? They actually robbed the bank and they got a bunch of money. But the problem is they now got caught. Okay, they got caught and they have been charged with robbery and the use of a weapon to commit the robbery, maybe a couple of other things, assault on the tellers at the bank. And poor Natalia is being also charged with aiding and abetting in the commission of a bank robbery. Okay. So charges have been made. What would happen is one of the very first things that would happen is Natalia and her husband would be taken to court and they would be read the charges against them. Okay. And they would be told you're being charged with commission of a robbery and aiding and abetting. How do you plead? How do you plead? Plead. To plead means, do you admit that you are guilty, or do you want to say that you did not commit the crime, so you enter a plea of not guilty, which is usually what most defendants do at that stage of the case. Okay. The judge says, how do you plead? Plead. Plead. How do you plead? Guilty or not guilty?
Means clarify. Yeah.
Question becomes, are you taken down to the jail and kept in jail on a permanent basis until there are further proceedings in the case, namely a trial? Well, the problem is, depending on what jurisdiction and what court that this is in, it might take 6 months, 9 months, even a year from the time when the arrest and the charges are made until there is a trial. Do you, Natalia, and your husband want to remain in jail for 6 or 9 and 12 months? Number one, the answer is no. And number two, can the community afford to have all these people who are awaiting trial be kept in prison or in a jail pending trial? The answer is no, because that's also very expensive, and there wouldn't be enough room in the jails or the prisons to keep all these people while they are awaiting trial. So what happens is there is a bond or a bail hearing, and that's what it's called, a bail bond hearing. And the prosecuting attorney who represents the state, and the defense attorney who represents the Natalia and her husband come into court, and the judge is in court. And the prosecutor makes a recommendation on whether Natalia and her husband should be freed on bail, meaning they should be allowed to go home and not stay in jail until they are asked or required to come back to court for further proceedings, whether that be a trial or something else. And the determining factors are, number one, how serious is the crime? If it's a very minor crime, usually the court will grant very minimal bail, maybe hundreds of dollars. On the other hand, if we have a very serious crime, such as a fire, which is an arson, a robbery, a murder, robbery of a bank, maybe somebody who has killed multiple people or who has, something really bad, or rape or something, then usually the bail is going to be set very high, okay? Or the judge might even say, you know what? This person cannot be allowed back in society because they're too dangerous, number one, or there is too great of a risk that if I let this person out of jail now, pending a trial, they are going to leave the jurisdiction. They're going to get on an airplane and go someplace, and the court will not be able to get them back for trial. Okay. So really two factors involved in setting bail. One, how serious is the crime that is being alleged? And number two, is there a risk that if this person is not kept in prison pending trial, they will end up leaving and justice will never be had against them? Okay.
We, we,
So,
we don't have
yeah.
we don't have this bail system in Uzbekistan, neither for
Ah,
serious crime
ah.
or for smaller ones.
Yeah. Well, this really came up, the reason for it, and this goes all the way back to the 1700s, after the United States gained independence from Britain and developed its own country and then its constitution. This is actually, there were 10 primary amendments to the Constitution. They're called the Bill of Rights. The Bill of Rights. And the Eighth Amendment contains a number of different clauses that all deal with criminal procedure. And one is the right to bail. The other one is no cruel and unusual punishment. And the idea here, the reason behind this, Natalia, is if you were to have a very brutal, maybe you can say corrupt, criminal justice system, the state through the prosecuting attorneys could just grab a bunch of people off the street, charge them with things, and then let them rot basically in prison indefinitely. And I can name a couple countries around the world, and you can probably think of them where this actually happens. So the right to bail is designed to really guarantee that this does not happen. And so what happens then is I want to go back to the prior slide. This is actually a sign for what is known as a bail bondsman. Then this is actually a full-time occupation for approximately 28,000 or 30,000 bail bonds companies in America. If you go anywhere in America and you go by a court where there is a criminal court, I can guarantee you that within about a half mile or a mile or even less of the court, you will find a sign like this that says bail bonds. Okay. And what happens is the bail bond company, this is actually a company, it's like a taxi driving company or the any other kind of business. Let's say that the judge in a hypothetical case says, I am going to grant you bail for a $10,000. Okay, well, most people don't have $10,000 lying around. You either have to come up with $10,000 and pay it into the court, or you go into the bail bond office and you give them 10% of the $10,000, which is $1,000, and they put up what is called a bond for the remaining $9,000. And then that gets filed with the court. That's called a bail bond. Okay, bail bond. And this happens, I would say, in probably 90% of cases. I'm just picking that out of my head. I don't know. But in most cases, the court at this early hearing is going to grant bail and allow a bail bond to be filed. Once that is filed, the defendant gets to leave the courthouse and leave. And the idea is because the defendant is on the hook for the $1,000, they're probably going to return to court when they have a hearing. Otherwise, they lose the amount of the bond, or we call that forfeiting the bond. Okay. Now, I just want to add one more thing. I guess I've already explained this. Even though the Constitution, the Eighth Amendment, allows allows for the right to bail, I just explained it's not guaranteed. You have a right to a hearing to ask for a release on bail, and in most cases, 90% of the cases, the court is probably going to grant the motion. There are cases where the court, in its discretion, again, for reasons that either the court considers the defendant too dangerous to society to let them out of prison pending their trial, or there is too great of a risk that the defendant is going to get on an airplane and leave. And in that smaller percentage of cases, the court has the discretion to say, I am denying bail. And in that case, the defendant is going to be held in prison pending their trial. Okay, and I'm probably already running out of time, which is really unfortunate, but I want to talk about a very important word. I think all these words are important, but I promised they would be small. And this word is bias, bias, B-I-A-S, bias. And I'd like to know, have any of you heard of this word before? Anybody?
Like biased nature
Yes. What does it mean to have a biased nature?
means that it contains of no, it characteristics of two different things. For example, something
Right.
contains
You're,
characteristics.
that's exactly right. And if I were grading your paper, I would probably give you full marks, even though you weren't able to explain it completely. But you're right, Natalia. Bias means having prejudice against somebody, or as I say in the first bullet point, a predisposition of a judge, an arbitrator, a juror, or anyone making a judicial decision against or in favor of one of the parties or a class of persons. So, in other words, it's basically a preconceived notion that a person has, and this is true even outside the law. Everybody has biases, okay? based on where we live, based on our nationality, maybe based on our religion. There are a lot of people in America, white people who are biased against Muslims now, unfortunately, okay, because of one person out of 8 million commits a terrorist act. And so some Americans are told all Muslims are dangerous. It's terrible. Or you're a white person and you have bias against black people, okay? Or you're a Christian, or, so there's all kind of biases, okay? So you can see here in my slide, biases can be toward an ethnic or religious group, women or men. Um, I talk in my classes when I teach quite a bit about the common law jury system. Okay. In Uzbekistan and in a lot of the world, your civil law is based on it's called a code system or a civil law system, relying basically on regulations and laws which are passed by a legislature, okay, or by the parliament. Uh, a distinguishing feature of American law is that in America and in the UK, they follow not civil law, but what is known as common law, COMMON. Okay. Common means in everyday English, ordinary. Okay.
Yeah.
That car that I'm driving is and I'll finish up in a minute. The car is a very common, or it's very common to see. It's very common to see hot weather in Uzbekistan starting in around June. It's common for it to be very hot, even up to 35 degrees. Okay, very common. The common law means law that was really developed over a period of hundreds of years by judges. Okay, judges in the UK and then in America would consider cases on a case-by-case basis, and they would develop that would apply in given case, all that common law. Okay, and in the common law system, another feature of it is the right to a jury trial. Okay, the right to a jury trial. And jurors are ordinary citizens that come from the area where the court is based, where a given case is being heard. Okay, and they are called into and they decide actual issues in the case. Okay, that's how the jury system. I could give a whole lecture on juries. I would ask students the same question when I'm teaching them. What do you think is better, having cases decided by a jury? In other words, people that come from the community, normal people like you and me, that come from the community where we live, or would you rather have, as is true in of the case decided by a judge? And almost always, the students would tell me, we think the jury system is stupid. Why would anybody want to have a case decided by jurors who never went to law school and know nothing about the law? I would much rather have my case decided by a judge who has went to law school, knows all about the law, and has practiced law many years. And what I try to argue in defense of the jury system is this four-letter word bias. Okay. And the fact of the matter is that many judges in my 37 years of practicing law, I can tell you that many judges were biased. Okay. And many judges in particular were biased against defendants and against insurance companies because they felt that insurance companies were standing in the way of, for example, plaintiffs who were injured in one way or another getting money. And so bias is important. There's certainly juror bias too when I was selecting juries for my cases. Yes, jurors had bias too. Okay, bias meaning, yeah, they could be predisposed to rule in a certain way or against certain people. But the fact is, judges also have bias too. And this is important for those of you who one day might be litigating lawyers and are handling cases, whether it's in a criminal court or civil court, or even if you're arbitrating cases, because international arbitration is very popular now, certainly in commercial cases where you have a contractual dispute. Contracts, big contracts often contain clauses in them that say that if there is a dispute, the dispute shall be resolved through arbitration. And then the rules of the arbitration will be set forth. And usually one party selects one arbitrator, the other party selects another arbitrator, and then those two arbitrators might select a third arbitrator. And even in the arbitration setting where you now have arbitrators deciding sometimes very big and important cases involving, millions and millions of dollars, you as the lawyer involved in this process are going to have to look at these arbitrators they're kind of like jurors because they're going to decide your client's case, and you have to look at this issue of bias. Okay. And how do you look at bias? Well, if they are professors that are, they've written extensively on whatever topic is involved, you might have to go back and look at what they've written. Okay, maybe they wrote books, maybe they wrote articles, maybe they've written on things on Instagram posts or TikTok, or they've given lectures. It's going to be your job as the lawyer representing your client to go back and investigate these potential arbitrators and find out, do I think they're going to be biased against my client? In other words, is there some reason based on their prior conduct or what they've written, or maybe it's even newspaper editorials that they've written? Okay, have they written things or ruled in other cases, similar cases, to give me reason to believe that they are biased, okay, that they're predisposed. So really bias is something that is a very, very important concept, and something that as lawyers you're going to have to be aware of as you go through your life as a lawyer, especially if you're litigating and are involved in arbitrations. Okay. Are we out of time, Dilsus?
Almost, yes. Thank you, Professor,
Okay.
for your
Okay,
beautiful.
let me do just one more. Can I do one
Uh-huh.
more? Okay,
Yeah.
one more. One more, and then I will quit, and if you have questions.
Okay.
But I want to talk about two more words, and I'll be quick. And the first one is bar. Bar, B-A-R, simple word, right? In ordinary English, bar has a couple different meanings. One, if you go to a place where you want to drink alcohol, we might call that a bar. You can call that a tavern. You could call that a cafe. In America, they're simply called bar. Hey, friend, meet me at the bar at 9 o'clock. We'll have a couple of beers. Okay. Bar can also mean bar can also mean a piece of wood or a piece of metal that is used to lock something up. I put a bar across the door so that nobody could break the door down and come in. Okay, so that's a physical object is a bar. Okay, a piece of wood or a piece of metal is a bar. If you were to go to a bar to drink, and then you got drunk and caused a fight and caused problems within the bar, the owner of the bar may say that you are no longer allowed to come into my establishment. I am barring you. Okay, so those are the ordinary English meanings of the word bar. In legal English, bar has a very different meaning. It is a collection of attorneys. Well, let me give you an example. It's better if I give you an example. I practice law in Michigan, and then I practice law in Washington State. I practiced in two different states. To become a lawyer in the state of Michigan, I had to sit for and pass a bar examination. They called it a bar examination. Once I passed the bar examination and I was sworn in by a judge to faithfully follow the Constitution and the laws and to carry out my responsibility as a lawyer to the public, I became a member of the Washington State bar exam. I became a member of the Washington State Bar. Okay. And there were, I don't know how many lawyers in Washington. Let's say there were 10,000 lawyers. Everyone passed the bar examination in Washington. We called all of the lawyers in Washington State members of the Washington State Bar. Okay. All of the lawyers who are licensed to practice law in Michigan are members of the Washington State Bar. Okay. All the lawyers in New York who are licensed to practice because they passed the bar exam and were sworn in as lawyers are members of the Washington Bar. If I were to practice law before the United States Supreme Court and I was given permission to practice law before that court, I would be a member of the Supreme Court bar. Okay. There's also bar associations. There's probably hundreds or thousands of bar associations in America, which are associations or organizations that lawyers belong to in order to socialize with other lawyers and to learn information about what is going on locally. For example, the Seattle Bar Association was an association of lawyers who practice law in Seattle Bar. That's for the lawyers. For the judges, we have a separate name. The collection of judges is called the bench. What is a bench? And this is why things are so confusing in English and then in legal English. What is a bench? A bench is something you sit on, right? You go to the park, you sit on a bench. Maybe at your house you have a long wooden bench that maybe you put around your kitchen table. That's a bench, right? A bench. On the other hand, in legal terminology, a bench is not an individual judge, but is a collection of judges. So again, and I'll end on this, if you were to go to Washington State, where Seattle is out in the Pacific Northwest, all of the judges that are in Washington State are called the Washington Bench. I don't know why, but that's just the way it is. So we have the bar, which is a collection of lawyers, and we have the bench, which is a collection of judges. Okay, I'm sorry, students and teachers and whoever's listening, but time goes by very quick, and we're out of time. And I know you have other commitments, and some of you have another lecture to go to in a while. So that's all we have time for today, unfortunately. But does anybody have any questions for me?
Comments, please, students.
Student,
Do you
anybody
have
have?
any? Yeah.
I'm sorry I had to rush through it so quickly.
Thank you.
Anybody? Nobody. Okay.
So, dear professor, may I share your email with my students?
Yes.
Thank you. And they can ask their questions, or Umidepe, do you want to talk maybe?
Uh, yes, good evening and good morning, maybe, to you, Professor.
Hello.
Thank you so much for the very productive presentation. We know that legal English sometimes has a biased system, as you
Oh, hello,
mentioned.
Professor. How are you?
I'm glad to see I'm still at the university.
Oh, I'm
Uh,
sorry to hear that.
yeah.
I wish we had more time, and I was telling Dilsus before we started that maybe we can figure out a way to get me to Tashkent, and I can spend time because it works a lot better actually if we can do these things in person. It's not nearly as effective doing these webinars, and if I can have interaction with everybody, it works better. But uh, I appreciate your having me. You're welcome to this presentation. You can use it. Dilsus can use it. You can use it. Your other staff members are free to use it. I gave Dilsus a number of other presentations covering all different areas of law. And again, I designed them for me because I have a certain way of teaching. I usually use both the PowerPoints and then a whiteboard, and I kind of go back and forth. And because I'm trying to teach both English and legal English and some grammar and some spelling and unusual things about English. Uh, but again, we just don't have time. We can't get a lot accomplished. But hopefully, my goal is if we can learn a couple new things, even if everybody learned 5 or 6 or 7 new words, that's great. These are such big topics. I spent my whole life learning English. I'm still learning English. I spent 45 years learning law. I'm still learning law. And
Wow,
to get through much in a short time is very difficult. So,
I see.
but you're welcome to my presentation. Use it
Thank you for
however you
that.
want.
So, so you still keep the system of a lifelong learning as your since in the vocabulary learning in this legal English terminology. We've been
Yeah.
knowing you for so many years, and actually we were waiting you in person last years. Maybe in the near future we can see you in person and you can visit Uzbekistan. We can host you with pleasure. It
You
will be
should
an
wrote
honor.
you should you should send me an email, or we can have another. I know I don't want to take up your students' time now, but you can email me, or we can talk separately and see if something can be worked out, because I have more time now for a lot of reasons. But yeah, I think we could uh, uh,
Yeah, we can talk that.
collaborate together, and I think it would be very useful. So
Yeah, because
see what we can do.
especially developing legal English terminology is crucial not only for law students, even we're being in this like more legal practitioners, and we're professionally engaged in the not context of teaching the content, but the language of this content,
Yeah,
international law, arbitration, all this legal consultancy, and we're proud that year by year our students are like advancing their enriching their vocabulary, and the role of the professors like you around the world is of great help and importance for us. Thank you so much, and I want to
you're
thank
welcome. You're welcome. Thank
Professor
you.
Driscoll for this. Hope
Thank
to
you
see
for
Thank you.
you in person very.
thank you for your kind words. And I follow what's going on in your department, and I know that you're doing a million different things, because I follow all the different webinars and all the visiting professors you have, and it's really pretty remarkable. You do a lot, so congratulations to you too and to your department. I know that every year, Uzbekistan's still relatively new country, just as Slovenia gained its independence in 1991. So I've actually been here since for 9 years, which is a pretty good period of time of its development, and I've seen a lot of how the Slovene legal system has developed, even in the short time I've been here, and I can see the same thing happening in your country. And I think your Tashkent University is doing really a great job in bringing together a lot of different experts I see from all over the world to really enhance the knowledge of all of your students. So really, job well done. I congratulate all of you.
Thank you
Thank
so
you.
much.
And thank you. Thanks for having me.
You're welcome.
I
By
wish
the
we
way,
could have done.
we have by the end of May spring law spring, which we have traditionally every year, and you can visit because almost all the lawyers around the world are attending, and you're welcome to visit you, and we can see you in person.
Okay, thank you, Professor.
Welcome.
Okay, good night. I know
You.
I know it's late there, so I'll let everybody go, but thank you very much.
Thank
And
you.
if anybody has questions too about what I talked about or the rest of my PowerPoint that we didn't have time to get into, feel free to send me an email and I'll respond to anybody who writes to me, I'll respond to you.
Thank you.
Thank
Okay, good night. Thanks,
a
Bill,
nice-
Susan. Good night. Natalia, everybody, good night. Students, thank you very much.
Welcome.
Enjoy
Thank you.
enjoy your spring there in Tashkent.
Thank
Yeah.
you.
Bye.
We
Okay,
will.
bye-bye.
Thank you.
Bye.
Bye.
Thank you.
Bye-bye.
Natalia, miss you so much. Nice to see you virtually.
Nice to see you too.
How are your kids?
Oh, well, they are okay, as usual, okay. I'm very grateful to you for this opportunity because I like Professor Heller very much. His lectures, his presentations are always very interesting and very helpful. Now, I have been working as a lawyer for 3 years, and still I don't know all these words which he has just mentioned. And though every day on my everyday basis I work with contracts, and these contracts are only in English, and
Oh,
still,
really?
yeah, and still I don't know these terms which we were talking today about. So
But
thank
we do appreciate as a ex-graduate and even the professional that you're still working on yourself, which we're really good, proud of. Thank
because
you.
because such lectures, they really help to improve your knowledge. They really help to improve your professionalism, and this is very valuable. And I'm very, very glad that even not still not right now I'm in studying in a university, but studying in England, I really have this opportunity to attend lectures in our university.
Yeah, great. We're happy that you liked it. Actually, we should thank Miss Dilsus for this opportunity to give everyone this kind of like a
just-
chance.
I remember our English classes during our first and second year, and I remember how it was difficult for us as students when we didn't have any knowledge in jurisprudence, how those lectures were important, because you as teachers, you also sometimes you cannot know some judicial meaning, some nuances. And such lectures, they just really help when a lawyer explains what it means.
Yeah.
So it's really cool.
Sometimes, yes, it's really complicated for us to comprehend the background knowledge behind.
Because on our second year, we don't have a judicial base. We are
Yeah.
just starting, and we have such subjects as
Foundation. Yeah.
history and theory of state and law, and we don't have even an idea what is it, for example, lien, or what is it, real property. We don't have an idea, and sometimes you as teachers, you also don't know, and you don't have an idea how to explain us in order we could
Yeah.
understand it. So thank you very much for this opportunity.
We are
Yes,
learning by doing still.
Yeah, I agree.
Have a nice
Okay.
evening, all. Thank you, Midapa.
Bye.
Bye. See you, Natalia.
I must go home.
Yes.
See you. Thank you very
Bye
much.
time.
One more.
Uh-huh.
Bye.
Yeah,
Bye.
have a sleep
Yeah.
Take another dress and come back in the morning. See you.
Thank you.
Natasha, come and visit us. Bye.